Evicting a tenant can seem like a complicated process, but in this video we'll quickly explain the eviction laws in Texas and outline some simple steps that landlords can take to initiate an eviction. We're eForms, the largest online database of fillable legal forms, and in this video we'll talk about what the eviction process looks like, how Texas laws affect evictions, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice that conforms with Texas law and that you can customize to meet your needs. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property. This is often called a self-help eviction, but if the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the courts. One thing to note is that an eviction is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. If a tenant in Texas fails to pay rent or breaches the terms of a lease agreement in some other way, the landlord can issue an eviction notice. In Texas, there are 3 versions of this form, and each one applies to a different situation. One is the 3-day notice to quit. This one gets used when a tenant fails to pay rent on time. This form tells the tenant to either pay the past due rent within 3 days or expect an eviction action to be filed in court. There's also a 3-day notice to quit for non-compliance. This one gets used when the tenant breaches the terms of a lease in some other way than failing to pay rent. This notice tells the tenant to fix the problem within 3 days or face eviction. The final version is the 30-day notice to quit, which gets used to end a month-to-month tenancy. This can be used either by the landlord or by the tenant to indicate to the other party that the lease will not be renewed at the end of the 30 days. The landlord should choose the appropriate notice to quit, fill it out, and make 2 copies. One copy should be saved in case the eviction proceeding goes to court. The other must be served on the tenant. The notice should be served via personal delivery to the tenant or any person over the age of 16 who is residing at the rental unit. Notice by mail is also an option, provided the landlord requests a return receipt. The landlord may also deliver the notice by securely affixing it to the outside of the main entry door in a sealed envelope. The tenant's name, address, the words "important document" in capital letters must be on the envelope. If the tenant doesn't respond to the notice within the allotted time period, then the landlord can commence an eviction action in the Justice of Peace Court in the town where the rental property is located. In order to commence this action, the landlord will fill out a form called a complaint for eviction and make 2 copies. In addition, the landlord will fill out an information sheet and a military service affidavit. All of these forms should be signed in the presence of a notary public before they are filed with the court. The court will charge a filing fee, and the amount depends on the county. The court will also set a date for the eviction hearing. The hearing will be no sooner than 10 days after the suit is filed and no later than 21 days. A copy of the papers must be served on the tenant at least 6 days before the trial. A sheriff or constable should deliver the documents personally. If the sheriff or constable tries twice and is unsuccessful both times, the judge can allow for a different method of delivery, such as affixing the papers to the front door of the rental unit. At this point, the tenant has the opportunity to reply to the claims being made in the complaint by filing a form known as an original answer. This documents the tenant's side of the story. Both parties have a right to request a jury for the hearing. This request must be made at least 3 days before the hearing. At the hearing, if the judge rules in the landlord's favor, then the tenant has 5 days to appeal the decision. If the tenant does not respond to the judgment, then after the 5 days, the landlord can file a form known as a request for writ of possession. The writ authorizes the sheriff to remove the tenant and the tenant's belongings from the premises. From notices to court documents, we've got everything that you need to get an eviction process started in Texas. You can access all of it at the link below. And don't forget to hit that subscribe button for more videos about important legal topics.